In the history of LGBTQ rights and their demand for greater civil rights in the modern Democratic Republic of India, when the Supreme Court decriminalized homosexuality in a curative petition, reversing its own judgment that was handed down, that was indeed the beginning of paving and charting the path for greater civil rights in India. Now, there can be no civil rights in any country without the recognition of same-sex partnerships. Whether they are recognized as marriages or some kind of special partnerships under special laws, that's the choice that any nation makes. Across the world, these are choices that democratic countries have made. What are the key options before the Supreme Court of India? What is it that the court can do? And we're trying to gauge these options from the elaborate hearings and tracking those hearings that happened at the Apex Court. Number one, the core argument is recognize marriage as a fundamental right. When you recognize marriage as a fundamental right, you cannot be denied that particular right and the exercise of it by any provision, by any other statute of law. Now, the recognition of marriage as a fundamental right indeed is problematic in various aspects. This was something that was also pointed out by the Centre before the Supreme Court of India, saying that, look, we have a broad ambit of personal laws in India, and personal laws do not recognize same-sex partnerships. If India at all wants to recognize marriage as a fundamental right, you need to have a uniform civil code, or you need to deal with the problematic aspect of personal law, say the Muslim personal law, the Hindu personal law, or the Christian personal law. And a lot of customary practices, more importantly, that exist under the 6th schedule of the Indian Constitution. None of the tribal rights or indigenous practices recognize same-sex marriages. And the sheer diversity of India as a cultural scape makes it very difficult for same-sex marriage to be recognized as a fundamental right. But that's the most ambitious argument that has been made by the petitioners before the Supreme Court. Let's see whether the court gives in to that argument or agrees with that argument in principle. Let's come to the second demand. The second demand is that if not recognition as a fundamental right, there should be recognition of a civil institution. Say a Special Marriages Act that recognizes marriages as a civil institution, as a secular institution, and it is not tied in any kind of religious norms or dogmas. Now, that's an interesting argument to make, but a lot of tentacles of marriage are always entwined in the sphere of personal law. Even if you're married under the Special Marriages Act, it is possible that the inheritance, adoption, divorce, and various other allied laws will have their own religious presumptions. Say under the Muslim personal law, the divorce is very different. What will happen to various other offenses that happen within a marriage? Say the dowry prohibition law or the Domestic Violence Act, all of them need to be made gender neutral. This is clearly a task which is not something that court can do on its own. It does require legislative interference or legislative effort as well. So yes, that entire suggestion that recognize marriage under the Special Marriages Act and make it gender neutral, the definition of a man and a woman should be done away with when it comes to the definition of marriage. Interesting proposition, but indeed the judicial minds will have to develop that proposition for it to be palatable to a diverse country like India, and it will also open a Pandora's box for the times to come. Because we'll see a lot of litigation. If special marriage, then why not under the Hindu Marriage Act? Then why not under the Christian personal law? So we are opening up that scape. The third one, and this is perhaps the most safe option that was talked about when that hearing was happening, set up a special committee which the centre can do under the aegis of the Supreme Court, and the concerns of the community can be put out to that committee, and a solution can be framed. There are certain basic rights that were discussed, which is to sign a medical consent form, to have a joint bank account, to be able to invest and take decisions on behalf of each other, God forbid there's a difficult situation. All of these basic civil rights are denied to same-sex couples. The court might decide to take a middle path and give some way for the community to have this kind of basic civil rights so that they're able to live their life with dignity. As we talk about these various options that the court can look at, one must highlight the overall sentiment of the hearing. The LGBTQ community demands dignity. It is not just about the institution of marriage, but it is also to honor the partnerships that exist between same-sex couples, which are marred by social stigma and religious taboos. It is about giving that recognition, and because it cannot come from society, because it has not come from anywhere across the world, law, judges, judiciary can pave a very important reformative role. As we've spoken about those three options, all eyes on the apex court, the Constitution bench led by Chief Justice of India, Justice D.Y. Justice Chandrachud, and what he decides, and all eyes on that big judgment.